Prachi, hello Prachi, hello Adi, how are you all? Hi, so this is Sanchita Ain. I'm an advocate on record in the Supreme Court of India. So as I promised yesterday, I'll do a webinar today. So here I am. So without waiting for, so I was interacting with a few students here and they're very excited. Some of them attended yesterday's webinar too, so they can't wait. So apparently I can't wait either. Let's see. So how to prepare if you have to argue before the Supreme Court? How did I start arguing? So what happened was I went to take a Passover and the judge was like, nothing doing, you need to argue. So that's how I started arguing. But what happened was when I started to speak, so on the other side, there was the senior advocate and he interrupted me and he started speaking, and I had this expression on my face because I didn't know how to respond and whether I should interrupt, whether I should speak. So I was just quiet and he had this expression, very annoyed. So the judge understood. He made the counsel quiet and he asked me to proceed. And he was very, very kind to me, and that's how I learned. But after that, of course, I learned to interrupt and make my point wherever I had to, right? So that's how I started arguing. Okay, so you do learn by observing other advocates argue, no doubt about it, but mostly you learn from your own experience by making mistakes, right? So that's how I learned. I'll try to bridge that gap for you so that you don't have to make as many mistakes as I may have done, right? So that's the purpose of this session. Now, what is the purpose of making oral arguments? Now, when do you make oral arguments? You've already filed your petition, but after that, why is there a need to make oral arguments is my question. So if you could start sharing, if you have something in mind, why do we, or even if you start thinking about it while we are discussing, why do we need to make oral arguments? What is the purpose? Krish and Bharti, I don't know who is typing, but both of them are attending together. It would be a confused situation with you at that time. Okay, so I guess this is in reference to my story. Okay, so the purpose, of course, part of what you said may be the answer to get rid of confusion when you, so the judges may be confused after reading briefs, after reading the other side's reply. You want to make it clear to them what the facts are. So what is the purpose? Let's look at it. Yeah, explain to judge quickly without making him read long pages. Right. So, Vivek, the thing is, many Supreme Court judges read, I mean, all of them would have an idea, at least a vague idea as to what the brief is about, what the case is about. So then why is there need to explain it to them, right? So if you understand why you need to make oral arguments, then you can work on it, you can improve, because you're then connected with the purpose of making it. Then you are not just confined to what the brief has already stated, right? Right. Priyanka will address your questions after the session, perhaps just remind me to do it, right? So what is the purpose of making? Let's look at the purpose, right? What is it that you're trying to achieve through oral arguments, right? It's because judges cannot read full documents submitted while arguments. Hence, it will be quicker to brief the court. That's what happened. Very well said. Judges cannot read the entire brief. So sometimes it could be that they have formed an opinion which is against you. So you need to be able to persuade them. You need an opportunity to do that. And oral arguments or the hearing stage gives you that opportunity to change the judge's mind. That's, of course, one of the purposes. So when you know that you have to be persuasive enough. In order to change somebody's mind, obviously you know the level of persuasion you need, right? Now, see, in an adversarial system, if you prepare well, argue properly, the nature of proceedings is such, it has the potential that it can convince the judge and persuade them in your favor. How? Right? What is it in the nature of adversarial system that can do that? So I'm making things easier for you. If you look at it in this manner, it will be easier for you to argue, and you won't feel intimidated that, oh, there's somebody on the other side who is far more experienced than me, because it's the nature of the adversarial system in itself that makes it easy. So how does it make it easy? Firstly, of course, the other side may commit blunders during the hearing, so you just have to wait. You have to wait very patiently and let the other side commit as many blunders as they want to without prompting. Right? So this is one of the mistakes some young lawyers do. They start jumping and they're like, oh, he's saying this, he's saying this. No, let him complete. Let him make all the blunders he wants to make. Otherwise, he'll be careful, right? So you allow him to make as many blunders he wants to make. If you are getting to know, the judge is also getting to know. He's also letting him do it. So just let him do. And if you think that the judge hasn't got it at the end, then you can, of course, point it out, right? The second point about adversarial system would be, if you can just rebut the other side's arguments satisfactorily without leaving any gap in your own arguments, then the judgment will be in your favor. It's that simple. You don't leave any gaps in your arguments, right? You become the devil's advocate, brainstorm, think what can be the gaps in reasoning. If you have not left any gap, you can rebut what the other side is saying to the satisfaction of the court. Your job is done, that's it, right? Instead of starting from the scratch and thinking, persuading, etc., your job is done the moment you are able to rebut the other side's arguments and your argument doesn't have any loophole, right? Okay, so sometimes, in fact, the other side's arguments will strengthen your arguments for the court. So when the other side is making blunder, what is happening? Your own arguments are gaining more strength in the eyes of the judge, right? That's why the adversarial system works. In these kind of settings, you can have a good oral hearing. And so it's not really intimidating then, if you look at it this way, right? So how many of you felt less intimidated when I told you all this? Yeah? Right. So how to know if the judge is thinking against me? Right. So you need to be observant. So yesterday's webinar, I was giving an example how I keep pointing this out. You need to be observant. You need to observe the body language of the judge. Certain judges respond in a certain way when they are not agreeing with you. You need to know that. So you need to go to every courtroom and sit for a while to understand. When someone else is arguing, it's way easier to observe and understand that the judge is not with him. So when the judge is not with you, you immediately know, right? Just like in your family, you'll get to know if your father is not saying something to you, but he's not agreeing with you, you get to know. Similarly, if you become familiar with the pattern of behavior of a person, with the body language of a person, it's easier to perceive and to understand what the person is thinking. Or at least the person is not with you, even if you don't know what exactly they may be thinking. But since you have prepared and you have already anticipated the questions and concerns that the judges may have, then you can also address them, right? Through oral argument, we can convey a case in a proper way, that's right. Perfect. So let's go ahead. Actually, what can be the other purposes? So one of you, of course, said you can convey it in a better manner, right? Clarity is one of the purposes, right? Let's look at. Okay, so what we'll do is I'll give you a fact situation, and throughout the webinar, we'll focus on that fact situation to understand the points, right? So the fact situation is, it's simple. A is accused of instigating B for committing suicide. So basically, A has been charged with abatement to suicide. Who has committed suicide? B has committed suicide. Okay. So A is in jail since more than a year now. Okay. So A was arrested. He's in jail. The trial is yet to begin. A's bail application has been rejected by the trial court, by the High Court. He has filed an SLP now in the Supreme Court against the High Court order. Any confusion so far? Even if you have not done criminal law, it will still be okay for you to just try to understand. If you have any doubt, any confusion, you can ask me. Right. So can a fresh LLB advocate, can you answer these questions at the end? Right, because it will break the flow. I really want to answer all your questions. We can have it at the end, right? We can have this kind of a question and answer session at the end. If you have any question pertaining to what we're discussing right now, you can ask me right now. Otherwise, we'll answer it at the end. Okay, works? So A is accused of abatement of murder of B. Sorry, abatement to suicide. Okay, so A is in jail since more than a year. The trial is yet to begin. A's bail application has been rejected by courts below. He has now filed an SLP for bail. Basically, he needs a bail and he has moved an SLP against the order rejecting bail. Clear? Okay. So now we know what he has been charged with. We know for how long he has been in jail, and we also know that the relief he wants, right? Facts are A and B were neighbors. B was having some problem at his office. B shared it with A. A told him that B can go to his office, call all the staff, and just pour some kerosene and light a matchstick. After 10 days, B did the same and was rushed to the hospital. He died of burn injuries after 2 days. So now in these facts, what other relevant facts? I'm sorry, I'm getting into a little bit of detail here so that later on when we talk about arguments and how we are going to frame it, it will be easier for you if you have understood the facts properly, not just correctly, but properly. So all of these facts are material facts, no doubt about it. Some of it will be relevant for you when you are arguing for bail. What will be relevant? In the slide before, we said he has stayed in jail for more than a year. That will be relevant for you. The trial is yet to begin. That will be relevant for you. Right? What did A tell to B? That you just pour some kerosene and light a matchstick. This will be relevant to you. How you're going to use it is something that will come to it later. After 10 days, B did it. This will be relevant for you. And then B died of burn injuries, right? So now all of these are relevant for you. It will help you to build your arguments. So this you noted, we'll keep referring to it. Now let's look at the purpose of arguments and see how. So of course, in the bail application, the SLP, first in the bail application, now in the SLP, you have explained all the grounds on which you are before the Supreme Court. It would be simple for bail. It will be very simple why the High Court should have decided otherwise, etc. You have taken these pleas in the petition. So now when you come before the court, how would you argue is what we are going to work on. Yeah, he suggested an idea to B. That's right. Did A ask B to pour kerosene on himself or the office? On himself. But he said just pour the kerosene. You first call other staff, pour kerosene, and just light a matchstick. Just pour kerosene and light a matchstick is what he said. So these words are again very important. Just pour kerosene and light a matchstick. So when you will be arguing for that person, of course, in the petition, it will all be clear. But when you are arguing, you just focus on your arguments, your legal arguments, right? So, and when you are doing that, you'll simultaneously, because all your legal arguments are ultimately going to be based on facts. So he just said this is relevant for you. Whatever legal position you take, you say that, oh, there's no nexus between what he said and what happened or the suicide. So then for that, you need to refer to this statement, right? That this is what he said. So you are simplifying it for the judge by way of your oral argument. So that's one of the things you are doing when you are arguing. So it's not just persuading, it's also simplifying. You're clarifying. Somebody said that, to clarify. Now, what are you clarifying and what are you simplifying? The facts, as I told you. So there would be many material facts, out of which you just pick those that are in your favor, that you want to use to support your legal argument. And you will then base your legal arguments on that, right? So therefore, you need to simplify and clarify the facts also, and make the judge focus on those facts by way of your oral arguments. The relief, so in bail it's simple, but otherwise there could be a situation where the nature and scope, the judge may have certain doubts or the implications of granting you that relief, etc. So you may have to explain the nature of the relief that you are seeking, or the scope of it, whether you want all of it. Sometimes in the petition you may have written, or the drafting counsel may have written a lot more points, but you may want to then confine only to some because the judge is not inclined, etc. So those are the calls you make while making oral arguments, right? So sometimes you will find a lawyer not pressing certain relief because he realizes it's not possible to get those. So let me put those aside and let me just press what is possible to get. So that's why you sometimes find arguing counsels to have counsels who are very used to arguing cases. They have that sense way better than those counsels who have just been drafting. So in Supreme Court, you can have a clear distinction sometimes. There are, of course, counsels who argue and draft as well. There are AORs who draft, argue, do both. For certain matters, they may be briefing. It's called briefing. When you are asking another arguing counsel to argue, then it's called briefing. That also happens. Like Justice UU Lalit, he was an AOR before he was designated as a senior advocate. But he still used to argue. He used to be briefed by other lawyers to argue their matters because he was good at it, right? So that is what can make you good arguing counsel, if you know what you can get and what you cannot get, and if you can sense it right there, that this is what is not going to work for me. That's also useful. Is Supreme Court all to present new evidence in case of SLP or 12? I didn't get your question, but I think what you're trying to say, can you produce new evidence? No, you cannot produce new evidence. Can you refer to them? Of course, the court will not get into facts, whether the trial court, there will be stuff that will remain matter of trial, and the Supreme Court won't get into that when it's deciding the bail matter. But apart from that, when you're making a legal argument, obviously it will be based on certain facts, right? To that extent, you can definitely substantiate with facts. It can also go into questions of fact when it comes to SLP. It does, to a limited extent. And again, you need to know how and when, right? So now, what will be the basis of your relief? In this case, it was bail, right? But otherwise, there can be three kinds of basis. One can be the legal position, right? So a certain case has decided the legal position in a certain way, which is in your favor. So that can be the basis of seeking a certain relief. So maybe the High Court has not considered a case that says that there has to be proximity. So since there's a lapse of 10 days, there was no proximity. The person had a time to think over it and make his own decision. Therefore, you cannot charge him with abatement, right? This can be ground. The ground, so this is a legal position that can be the basis, right? The other basis could be, let me read this. 10 days make the case even more favorable for A. B had sufficient time, yes, Vivek, to make her own decisions. Even if it was 1 hour, I would still argue that B is an adult and is responsible for making her own decisions. A might just hate B and misguided her. You cannot put someone in jail for hatred and misguidance. God has equipped. Okay, so you don't need to go into God, etc. You don't, yeah, but to that extent, you were making a valid point. But don't go into too much of rhetoric. I mean, you should use them, but don't go into, yeah, it doesn't help. So, and the other thing that does not help is character assassination of the victim. I'm just saying all these to you, but of course you can, just why can't we put that person in jail? Because you are arguing for that person. You have been hired by that person as he's misguiding, putting a wrong thoughts into him. So Krish, you've been hired by the accused to argue for him, right? So we are not here to decide what should happen. We are here trying to see if you have been hired by A, what will your arguments be before the Supreme Court? How can you argue? How can you persuade? So to the extent you start, I think you started off quite well. And but after that, I think you just got carried away with that argument a bit more than was necessary. Okay, the other basis can be interpretation of law. This is generally, right? So it can be either constitutional law, it can be statutory law. So, so Supreme Court arguments are all about interpretations, because mostly they're looking at questions of law, substantial questions of law. So therefore, if an interpretation is wrong, so this is the best thing you can do for yourself if you are a student. You start looking at the language of the provisions. Of course, your command over language has to be good enough for you to be able to interpret. And you understand why in a certain case, the court interpreted it in a certain way, right? So that it kind of opens your that side of the brain that uses logic a lot. So you can then use logic whenever you are arguing, not just in framing your arguments. So it's not just your arguments that need to be logical, but also interpretation to some extent when you are even doing literal interpretation or you're doing harmonious interpretation. So I think it's important for you, therefore, to keep interpreting. It's like you're playing with words. So keep doing that. That will be useful when you are into litigation, and reading and understanding the positions of law. That also helps you. So sometimes it happens, when you read a lot of these and you know a lot of these legal positions, then you can also think of different legal propositions, right? It's easier for you to frame legal propositions, that there must be a case saying this. So that's how we ask our people who assist us to find cases, to do research. You need to have a legal proposition in mind, and it helps when you read a lot. Then it helps for you to understand what kind of things can the Supreme Court say, and it would have said at some point. So let's find it, right? The other basis can be violation of fundamental rights, which is, of course, you have writ jurisdiction where you do that. But even otherwise, if the High Court, its order has violated your right in some manner, then also you can say that, right? So that is the basis of the relief on which you will base your legal arguments. For example, in many landmark judgments, the Supreme Court has said bail is a rule, jail is an exception. Exactly, we can quote such judgments. So actually, the thing is, Supreme Court, I'll come to that point in a while. So what happens is, most of the things that you think is like huge, the judges of Supreme Court already know it. It's very obvious for them. So instead of saying this aloud, because everyone knows this, right? Everyone in the corridor walking there would know this, that jail is the exception, right? So how do you use it in your arguments? How do you show without saying it, right? So all that matters when you're arguing before the Supreme Court, rather than in other courts, sometimes just emphasizing on a certain point helps, but in Supreme Court, if you can use it, and a lot of court craft is involved when it comes to Supreme Court. So we'll try to work on how you can develop such kind of code. It's something to be developed, something to be practiced, right? So we'll see how you can do that. Okay, so impact of the relief being granted, not granted. So this is another aspect that you have not specified. The format of the petition doesn't allow you to talk about what will be the impact. You can specify somewhere in the facts, but that gets lost. Otherwise, in the grounds, again, you can say that because if this is not granted, this will happen. But that may not seem to be such a strong ground when you're drafting a petition, whereas when you're arguing, it can have a very persuasive impact. Okay, how to find a question of law? Very good question, but that will require a separate session. So there will be many interesting questions, I'm sure, but I can't end it at 10. I don't know when will end. I hope you guys are okay about being with me till midnight. I'll answer all the questions. Don't worry. Okay, so considerations based on equity. Again, this can have a persuasive value when it comes to Supreme Court. Remember, Supreme Court has 142. It can do anything in the interest of justice, but only if you can persuade it in a certain manner without going like the way somebody said, like, God and stuff. But yeah, there can be equitable considerations that you can point out to the judge, and they do consider, right? So again, seeing what the judges have said in the past helps to build your case, to build your argument based on equity, right? So this is again something the petition doesn't allow you to do to that extent as your oral arguments would. Addressing questions or concerns judge may have. Again, the petition does not do that. You may have those questions and concerns in your mind when you're drafting, but really there's not much scope to address them in a manner as you can do when you're arguing. So again, anticipating it is very important so that you can plan what you're going to say when the judge asks you that question. You can apply your, so sometimes you may think of one argument and you may miss another one. When the judge has asked you a question, sometimes you may have to apply logic and explain to the judge. Maybe sometimes you may have to use some example and explain it to him. So if you do all that beforehand, if you plan it and then go to the court, that's why you need to prepare. So it's not just what you are going to argue, but what the other side will argue, anticipating that, how you'll rebut, what the judge may ask you, what if the judge keeps interrupting you because the judge is not with you, right? What can that question be if the judge is not with you, etc. So all these you need to have in your mind when you are preparing. Okay, any questions so far? Arafat is asking, can we be provided with a written draft on how to prepare oneself before Supreme Court? So are you asking for a petition? Are you asking, oh, you want a written material on how to prepare for arguments? Right, so see, I think what you'll have right now is what I'm speaking, but if you want me to recap at any stage, I can do that for you. But other than that, written material, okay, I'll talk about a course that I've developed. So, I mean, if that's useful for you, but other than that, that's why I've written all of it down for you in the slides, but that's the best I can do for you. This will be on YouTube, you can watch it again. So the other aspect is personal impression. This is very important. Okay, so Dileshwar is asking, in trial court, it's a public prosecutor on the opposite side. What will be on the, who will be on the opposite side? So it can be government counsel. If it's against the state, bail matters, etc. Obviously, it will be so if it's state of UP, there will be standing counsel of state of UP. If it's Union of India, there will be one of the law officers. Yeah, it can be ESG or SG, AG, right? Mostly ESGs appear for these matters if it's Union of India, right? Okay, so otherwise it can be private parties if it's a private party, of course, whoever. Okay, so personal impression is again is very important for an arguing counsel. Why do you think so many lawyers assist an arguing counsel in the Supreme Court? If you have been to Supreme Court, you would have realized there's at least one lawyer who's constantly opening the pages and giving it to the arguing counsel, or who's prompting. If the judge asks the page number, the lawyer will have a note handy and immediately they'll prompt the page number. Why is it so important to be so quick? So why is it so important? It's because that's the test of your reliability. Whether you are so thorough with your facts, whether you are so thorough with your law, that is all on your fingertips. It's only then that you meet the reliability test. That's why they'll always carry a note. That's why they'll always have, otherwise you can turn the pages and tell the judge when did it happen, oh date, let me find out. That's how it works in the trial court, right? But in Supreme Court, the lawyers won't take even a few seconds to answer that question. Because that's basic, you ought to know before you walk in. But you can't remember all of it, therefore you carry a note with all the points written on it, with the dates written on it, with all the relevant facts that we were talking about. So you'll have all those dates written on a piece of paper beforehand, before you walk into the court, so that the moment the judge asks, when did this happen? Oh, when did A say this to be? This date. And when did the person committed suicide? This day. Oh, 10 days gap, right? So you need to be able to point out the exact dates. That's why you need a note. That's one of the reasons. So that you can leave a personal impression on the judge. That's part of what you're doing. Okay, so why, again, judges do remember. So even if you have argued well in a case before, the judge would remember and he would be looking forward to listening to you. They remember names. Sometimes they don't remember last name, they don't remember first name, sometimes last name, etc. So that happens a lot in the Supreme Court because you keep arguing before the same bench again and again. So therefore they do remember you, and that personal impression does work for you. So therefore it's important. Okay. Why are arguing counsels assisted? So this we have already covered. The other bit is conviction. Something I keep talking about. You need to speak with conviction, and the conviction should get conveyed through your eyes, through your body language, everything, the way you talk, the way you walk, everything, right? Okay, reasonable. So the thing is, when you're arguing, all of this personal impression will have an impact on the outcome of the case. It's difficult to appreciate this, but it can have an impact, and therefore if you want to be impeccable, you need to be perfect about all of these. So there's some lawyers who are known to be reasonable, right? Like Mr. Salman Khurshid, he's known to be a reasonable person. Why? Because he won't make an unreasonable argument. He'd rather mince his words and say, yeah, this happens, but you know what, in our case, this has happened. So at least my lords may consider this, right? That's how he argues. So sometimes some clients may not be happy, but sometimes there are clients who come to him just for this reason, that the judge knows you as a reasonable person. And therefore, if you request him, if you seek more time, so in cases where it's open and shut, there's nothing that can be done. The order is against you. There's no legal position in your favor. Still, Mr. Khurshid stood before the judge and asked for time to settle the matter. Just for that, the judge gave the client that time. That could have been done only by him, is what the perception was, and therefore the clients came to him. So this kind of perception is not just created in the minds of the judges, but in the minds of other lawyers who are listening to you, and thus in the minds of the clients, because these lawyers will then advise the clients whom to hire. Okay. Thorough knowledge of law. This is in the part of personal impression that the judge needs to get from you, and therefore you'll see that everywhere where the citation, the name of the case, everything is written. It's not like, oh, I have to look for in which case this was said, etc. It's all ready, right? Okay, why should you prepare well? Just knowing the arguments, would it suffice? Like just now we are preparing, you know what to argue. Would it be okay tomorrow morning you can go and stand and argue? Would that be fine? Or do you need to prepare? Because judge might question. Yeah, so you need to prepare. That's good. That's, of course, one of the reasons why you need to prepare. Right? You may know everything. It's all written in the petition. Why can't you just go and open the petition and start reading up? What's wrong? Does anybody do that in the Supreme Court? No. Right? It will never be enough. See, the reason why you gives bad impression, yes. The whole purpose of having that hearing is gone. If you're going to do that, then why do you need it even? Right? Therefore, you need to understand what you can do. And this is for everyone. I mean, not just for Supreme Court, but what you can do with that hearing. How much value can you add to that case? So if you just go and say what is already written in the petition without preparing further, and when I say preparing, let's see what it means. So if you already know the arguments, what else can you prepare? Why will you prepare? Let's see. Right? So if you have not prepared well, what can happen? Let's first look at that. You may miss a point. Therefore, it has to be all written down. Even if it's bullet points, numbered, whatever, one word, phrase, but it has to be written down somewhere. Otherwise, you'll forget. Right when you start arguing, you'll forget. Therefore, it has to be written. Okay, how to submit citations in the court and what are the facts we have to consider before submitting citations? We may miss some facts which are essential. So yeah, submitting citations, we have done an entire workshop on how to brief senior advocates. You can find it on YouTube. So we did this part where you can prepare a compilation of judgments and file it. So in Supreme Court, many people do that. You file, in fact, it's advisable even for the courts so that the courts have it at one place. So if there's two, I mean, if it's a division bench, then you are, or it's a constitution bench, depending on the number of judges, you make as many copies and you hand it over, right? So so it can be just few judgments, it can be many judgments. If it's few, you can even give the citation. So you give the citation beforehand in the library. They send the books to because it's very difficult when you're arguing for the courtmaster to find it and give it to the judge right at that moment. Therefore, you give the citations to the library and they get the SCC volumes. So before you start your arguments, it's already there. And if you tell the page number, it's already marked. The person will flag it beforehand, the courtmaster, if it does. So all that's arranged before, and the moment you start arguing, you're referring to so-and-so citation, the courtmaster is handing over that particular SCC volume to the judge. That's how it works, right? So that's definitely one of the ways. But sometimes, what if the judge misses? The judge forgets to write the citation. Therefore, it's advisable to file a written submissions once you have finally argued. There you can mention the cases you are relying upon, etc. Right? Sometimes the judgment can be reserved and it can take a while for the judgment to be written, etc. Therefore, you don't want them to. It had happened with us, and therefore I always remember to file written submissions. Right. Okay, can we take questions? Yes, Mahavir. Go ahead. Okay. Shubham, do you want to ask? Great. So if you have not prepared well, you may miss a point. That's number one. And therefore, you need to have a note. The other thing that you may do is, you may not choose the words carefully, and wrong choice of words, even at one place. So I've given you an example, and this happened right in front of how the bench is decided in High Court and in Supreme Court that the case will be listed to single or two or more. Okay, so this is a very, very different issue. I have to explain you the constitution of benches, composition of benches, etc. So I think we can keep it for another day. So I'll at the end tell you about the course and what all we'll be covering. So it's part of that course, but otherwise, I know you all have so many questions. Let's see. Okay. So this example is, so please confine your questions right now to what is going on. Yeah, because this is very interesting what is going on. So if you have other questions, I understand you must be having, because I referred to division bench and constitution bench, you had that question. I understand, I appreciate. So if you could please ask those questions, because I'm taking questions like while doing the session. Therefore, it's important that you keep it to the point. I'll address those questions as well at the end. Okay, so you may no, so the case I was referring to, the counsel appearing on behalf of the husband said, "Oh, the husband is still willing to keep the wife." This did not go very well with the judge. The judge was with the right. So that's right, Vivek. Husband wants to stay with the wife instead of right. Exactly. That's how, if he would have just changed the way he had said it, because the judge was with the husband's counsel on this file. He said this, and that put him off. So you can avoid saying such. And you know you will avoid if you prepare and then you go, and you're careful about choosing words. Right. If you have not prepared well, the arguments may fall apart. So, so suppose, so it made it very haphazard, right? If you have thought, okay, this, suppose I wouldn't have prepared these slides, and it would have been like, oh, fine, I'm going to talk about this, I'm going to talk about that, and then I talk about two things, I don't talk about the third, or I mess it up, right? So that's in the thing that can happen, that the arguments may fall apart, and I've seen arguments falling apart because either the counsels were too confident and had not prepared. So these things do happen, and therefore you need to prepare well, right? But if you take care of the gaps, now what happens if you prepare? Because when you're preparing, constantly you have those counterpoints in your mind. Oh, but what about this? This I have to take care of. I have to take care of. So you're filling in the gaps throughout, right? So once you do that, and therefore you see when the senior counsels prepared, so you're briefing them, they're taking notes on the first page of their brief. They're taking notes. They're like, yeah, this I'll argue, this I'll argue. Then suddenly they'll realize, what about this? They'll put an arrow and then they'll write something there, right? So this is how you'll find their notes. I mean, it's very, the reason why it's like that is because suddenly you have a counterpoint in your mind and you're like, how do I address this? Okay, it's at page number so and so. If you show, oh, it's okay, fine, great. Let me write it down there. They always connect the thoughts, and that's how they prepare notes. Okay. So you have anticipated and prepared. So we have been talking, and somebody also pointed it out that it helps to answer questions. It helps to anticipate, to prepare the answer beforehand, right? I'm not going to get into detail because we already covered. Okay, you can say you've prepared well enough. So if you have done all of this, you can definitely say. So what all points did we discuss? When can you be said to have prepared? You're looking at the gaps in the reasoning. So when you're preparing, you're looking at it as a whole, right? So you're looking at, and not just one point here, one point there. You're looking at it as a whole and seeing if it's going to persuade the judge to decide in your favor, or is there a gap there? Well, what if the other side says this? What if the judge has this concern? What if somebody is relying on so-and-so case? So do I need to distinguish that case? Because the facts of the case was different. I have a case where the facts are similar. So I'll then emphasize on this, right? So this is how you're preparing. It's not in a linear manner. It's like, yes, you build it up conceptually. And then you are in a better position to argue, and you also don't miss out any point, right? So I think these were the points. And of course, you're anticipating and preparing for the questions. Without that, you don't go. Otherwise, you're not prepared. Okay. So, right. So this is an important aspect. You see lawyers coming out of the court if they have got adverse orders. Some of them will be blaming this person, that person, and everyone on this earth. But if you have prepared well, then you can just say, oh, it is not my day. Right? How to prepare? That's why we're sitting here today. Right. I hope you guys will sit through this. Prepare a note or outline, right? We talked about this, why you need to do this. So if you're a fresher or not comfortable, it's okay to write everything on a piece of paper, how you're going to say, because you don't want to use the wrong word, etc., right? You may be nervous when you go there and argue. So therefore, you write everything down, there's no problem. There are lawyers who won't tell you this, but you do that. Initially, you do that. You write everything down, right? And then, but you don't read it out from there. You don't read out. You can carry it. And in fact, senior advocates do carry. Sometimes there are lawyers who write so much and they carry it, but they don't read from it. They refer to it, right? So some people need to look at, say, one phrase and they remember. So you need to have those prompts with you that will help you to argue. That's what you need to do. You need to have an outline. You need to have something, whatever works for you. And you can carry your entire document. That's not a problem. Initially, if you want, you can always write the entire thing on a piece of paper. How you're going to argue, right? You imagine the courtroom, you imagine the judges, and you practice. You do that, and you practice as many times as it takes to get it to reach perfection. There's no problem in doing it, and in fact, everyone does it at the beginning. Right. So I told you, nobody does that. Don't do it. It can make the hearing very, very boring. The judge would have read the petition. Why are we having the hearing in the first place? Do remind yourself that whenever you go for a hearing, any hearing, anywhere. Okay, why do you prepare a note or outline? If any of you has to leave at 10, please let me know. Yeah, because I want to discuss something at the end, then I'll discuss it before. Yeah, so why do you prepare a note or outline? We already discussed this part, right? To plan, to stick to the point. For reference, you're also writing which page number, which document, which case law, right? To organize in the exact order you want to follow. These days you have laptops, etc., so you can, but otherwise lawyers, they just put arrows and stuff, or this I'll first argue, or they number it, right? So you also need to organize and you need to plan the order. Do not start with a revolutionary argument, okay? So sometimes you can be very excited, particularly it happens with the drafting. If you've also drafted and you're arguing it, you can be very, very sentimental about all your arguments, but you need to understand that some of it may not stick. Therefore, you don't start with that. You may make it at some point, and you never know which point can stand out. Like once we were arguing before, Justice Lokuran, and our weakest point was that the lawyer didn't make it to the court. He was given sufficient opportunity, he still didn't go. Justice Lokuran didn't hear us on any other ground. He was not convinced. On that ground, he was like, oh, natural justice violation, yes, remand back. Right, so you never know which point will work. Chronology of events, that's right. So therefore, you have a list of dates with you, because the list of dates that's there in the petition. So the first question I had asked during my internship with a senior advocate was, why do I need to prepare? Why do I need a list of, we need to prepare a list of dates? For me, the note was a list of dates. I was like, why do I need to prepare a list of dates when it's already there in the petition? So unfortunately, the junior counsel didn't have an answer, and they later figured out that you need to have it on one page, just the relevant list of dates. In the petition, you're including all the material facts with, as a matter of disclosure sometimes, and sometimes they are material facts. But when you're arguing, you may not need all of them. So for whatever you need to have it on one page. That's the significance of having a list of dates on one, right? Along with page numbers. That's useful. Okay. You can prepare different notes. So see, if we are, for this example, the fact situation that we were looking at, the criminal law case, right? So criminal law cases, what can you have? You can have different kinds, right? So a list of dates is fine. You can have outline of grounds, say bullet points of what you can argue. It can be part of the same note. And then what else can you have? You can have a list of witnesses who said what, maybe in a tabular form, just one line, right? You can have, say, recovery, whatever. In this case, there may not be, but suppose there was something that may be relevant. In this case, it's not, but in other cases where it's relevant, there are too many recoveries, and you write down from whom what was recovered in a tabular form. Who was charged with what, if there are too many accused. So you can have different kinds of tabular charts to help you when you're arguing, so that you don't have to turn pages, because it also exhausts you when you're arguing and want to be very focused, and therefore you have all these kinds of information with you on a piece of paper. You just need to refer to that if the situation arises. It takes off so much from your head. You don't have to remember everything. It's there with you, right? You can also have an index of cases. Index of cases, you can prepare, the one that you prepare for yourself can be a bit more detailed. You can write exactly why you're referring to that in which paragraph, so that in case you don't want to refer to something, you quickly realize that, oh, this I don't want to refer right now. Right now I want to refer to this. So it's difficult to remember everything, particularly when you're arguing. Therefore, to carry it with you can be useful. You can ask somebody else to do carry. That's useful, right? Okay. हिंदी में भी बताओ. Dinesh, what we'll do is we'll do a Hindi wala session alag se. Abhi ye log bhag jayenge. So let's do Hindi. I want to really do, and at some point I will do. So do join us when we do it. Right. So do you want to learn how? Okay. So I think we don't have time right now to learn how to prepare a note or outline. What I'll do is I'll give you my email ID. You can prepare a note on this fact situation, and you can send it to me. I'll give you feedback. You can either write down your entire arguments the way you want to argue it orally, just like somebody wrote in the chat box, or you can prepare the list of dates, grounds. I mean, you can do both. You can do either. Your choice. Okay. I'll just write my email ID here. Sorry. I hope even those who are watching me on YouTube can also see. It's ain.sanchita@gmail.com. Yeah. Will you do? Say yes if you will do. If you don't want to do, that's perfectly fine. Yeah. Who will do? You guys will do. Great, great, good, good. Good. I'll send you my feedback once you send it to me. Okay. Good. Right. So what can we do next? We still have time. Yeah. So just remember, there's no hard and fast rule. You don't have to follow. Thank you, Abhilash. Thank you, everyone. Okay. So there's no hard and fast rule. You can do it the way you find it convenient for yourself when you're preparing the note. Yeah, it can be different for different cases, right? So for all the cases, you may not need an index of cases. Maybe there's just one case you're going to rely upon, then you don't prepare, right? There could be cases where you need a kind of roadmap. There's so many arguments, there's so many documents to be referred to, that you need a very long document that will tell you which document you'll refer first and which document after that. So it's not just about the arguments, then it's also about referring to those documents in order. Maybe that's crucial for the case, that you first refer to this document and then to this to build up your case. So then you prepare that kind of a roadmap. We did that in the auto spare parts in 2G. It really worked for us because we knew how to build up the case just by looking at which document we are supposed to refer. Okay. So always remember who your audience is. So just like somebody said, jail is exception, etc. So just remember, when you're arguing before the Supreme Court, I'm not saying you assume all the knowledge, but still it can't be a 𝗏𝘂𝗬𝘃. Sorry, is somebody speaking? No. Okay, so it can't be a worm's eye view. What is a worm's eye view? There's a difference between bird's eye view and a worm's eye view. So worm's eye view would be if you're looking at something like this, like when in moods what you do is you're actually looking at the law from here, and you're being so fascinated with this is the law, right? Nothing wrong when it comes to mood, because you're expected to do it that way. But when you're before the Supreme Court, you are either looking at a panoramic view and you're explaining, oh, this is the world view and this is how things are working, and therefore this violation of right is something that cannot be tolerated, etc., etc. Right? Admission stage, Nupur, good question. So, okay, so for this, Nupur, you can see my webinar on how to get notice issued at the Supreme Court. There is just 1 hour session on this, on how to argue at the admission stage. So that may be useful for you, right? So, yeah, so remembering that can be useful, giving them a bird's eye view, giving them, so when you're looking at the law from the top, I hope it's not getting too conceptual, but the point I'm trying to make is, as students, it may look like, okay, Mahendra is asking, can you please give some light in the context of interim order? What is the application for? Recall application for, okay, so you guys are asking me too many questions on procedure, on so many things that it will take a lot of time to answer these questions. Is somebody not on mute here? Okay, right. Okay, so let's stick to the point for a while. If you're so interested, there's a course. If you're so interested, let me know. I don't know what I can do, but I can definitely do something about it, or maybe it will get covered at some point during the workshops and the webinars that we'll be doing over the next few days. Okay, so what may be new to you? Maybe pretty obvious to them. Something I was explaining once. Most of them already know. So they read the file, they know what you're going to argue. So then how will you make it persuasive is the question. So keep these points in mind. So when you're emailing me your arguments, keep these points in mind while framing them, right? You need to see what is it that they may disagree with. So this is part of your brainstorming session that you do with your colleagues. Which part is arguable, debatable? Then what do you do with that part? You improve further. How can you strengthen that argument further? Should I use, okay, so should I elucidate? Should I give examples, anecdotes, right? So that can add clarity. Giving examples can add clarity. You can use language in a manner so that it can be made relatable in certain circumstances, right? Or you can find additional judgments that may be slightly on a different point, but it's useful for you in that particular case, right? So you think on those lines then, if you have to strengthen your argument, if you see there's a loophole there, or the other side can pick something up. Okay, raise the bar. So when you're framing when you're preparing and you imagine, I asked you to imagine, right? So you imagine that they're not agreeing with you, then what do you do? Yeah. So in that imagination, that world that you're imagining, what are they saying? Suppose they aren't letting you speak, then what do you do? What are you saying then? What would you say then? Right? So if you imagine and do it, I think it's very useful. When you're preparing, prepare for the worst. I think when you're preparing for anything, even for life, I mean, when you're preparing, prepare for the worst. When you're hoping, hope for the best. Right? This is my gyan for the day. 2 ways to make it persuasive. Remember this when you're framing your arguments, or when you're preparing the whatever you will be sending me. You either make a logical argument to make it persuasive. So you obviously base it on fact. You are making a legal argument. All that's fine. I'm saying what can you add to it to make it persuasive, right? So you make it logical. You add a logical argument, right? And you can use narrative techniques or rhetoric. To what extent you can use, how to use, all this can be best illustrated just like somebody was telling me how they'll argue. So I could tell that this you may avoid. So similarly, when you send me, I can give you those feedbacks, right? So don't just confine yourself to technical points, look beyond. So when you're arguing before Supreme Court, you ought to look beyond and assess the implications. So you not just confined to, oh, law says this. So that's what people do when they practice in other courts, and then they go to, like Jay was saying, he intends to practice in Rajkot. So when you go to Supreme Court, just remember this, that when you're arguing before the Supreme Court, you need not confine yourself to just technical points. Of course, you do argue those points, but along with that, you assess the implications. You also raise that before the court. You point it out that this is what will happen if my client does not get the relief. This will what will happen to others who are in the same situation. Yeah, the implications. So even the future implications, the judges do have all of those in mind. So do take care of that when you are arguing. Don't have that tunnel vision that, oh, my client, so I need to just focus on this aspect, because the judge is looking at with the implications their judgment is going to have. Like it will have an impact on the country, right? So they're looking from that perspective. So you need to appreciate that. You need to address that. So when you're anticipating the questions and concerns, you also need to anticipate and appreciate this concern of the Supreme Court judge. That's constant. So there are a few other sessions that I have done. I think I've covered this in great detail in those sessions, so you can have a look at those. It would be on the YouTube. Okay? Few more tips. Last tips before I leave you with this. Do make a note. Have these in mind when you're preparing the assignment I gave you, right? Plan where to take pauses. So when you're preparing that, I want you to write there where, after which word you're going to pause, or after which sentence you're going to pause. So you need to plan your pauses as well. Just like a theater, I always give example of a theater artist. I don't even give an example of a film actor. Theater artists, I mean, all the good senior advocates today have some exposure to theatrics, to theater, right? So it helps. Just getting your act right helps. So see so it can be different for different people. Like different advocates have different styles, but it works for them. So you can have your own style, but I really want you to have one. I really want you to start building one. It takes a while to get there, to have your own style. I want you to do that. Yeah? Keep imagining when you're preparing. Are you sounding emphatic enough? Fresh LLB, okay. Right. So fresh LLB, there has to be 1 year of experience before you can argue any effective hearing in any effective hearing. Other than that, you can mention. If you are a fresh graduate, you can always mention matters. Mentioning would mean you can seek adjournment, or so before the matter is called out, when you go and then you seek permission of the court and mention the matter. So it can be either for a matter that's not listed on that day, so you want an early hearing, then you mention the matter. There are different procedures, it keeps changing, so you need to know what exactly the procedure is for listed mentioning for. So if you want to seek time to file a rejoinder, permission to file rejoinder, etc., because the time has already lapsed. For all that, you need to mention and get these things done, otherwise the registry does not allow. Right? So these kind of things can be done by a lawyer who has less than 1 year of experience. Other than that, for any effective hearing, you need to have at least 1 year experience. But any advocate can argue. You need not be an AOR, you need not be a senior advocate. Any advocate can argue so long as there's an AOR in the picture, right? So the filing has to be done by the AOR, and on paper, the AOR is instructing the advocate. So it's mandatory for the AOR to be there, but that's the AOR's idea. So when you're imagining yourself arguing, you try to see if you're sounding emphatic enough, right? You analyze, keep analyzing yourself, keep observing yourself when you're doing that. Do it aloud, just like artists prepare. They speak to themselves, they hear, they record, then they listen, right? That you also check if there are variations in pace. It can get very monotonous, very boring if you do not do that? Are AORs only entitled to filing, or do they also argue? They can argue as well. Yes, they can. So the thing is, it's mandatory to get the filings done through the AOR, but that does not mean AOR cannot argue. AOR can argue. Any advocate for that can argue, including. Okay, so check that, otherwise it gets very monotonous. And if it gets monotonous, the judge won't be listening. That's why you need to have variation in pace. What else do you need to have? What about voice intonation? Somebody asked me this interesting question. I wanted to do a workshop just on voice intonation. I mean, on the basically how to train your, so that the volume increases, but you do not sound shrill. Otherwise, it can sound rude to the judge, right? So how do you increase the volume and yet? So, lawyers do work a lot with their voice box. So you can also think a bit what you can do to bring that kind of voice intonation and to play with not just language words, but also with the way you speak, and see how you can sound different just by laying emphasis on one word. It may mean something else. It may mean it may become more emphatic, or you may want to emphasize on some other word. So all those decisions you can make when you are preparing, right? So it can be that minute. Once you get used to it, then it comes naturally. But to reach that point, you need to develop, as I'm saying, you need to develop your own style. It doesn't otherwise come naturally. You may think, so everyone has a style, but ultimately you need to find it for yourself. Right? And that takes time. Then you need to polish it further. That takes further time. Any advocate can argue, yes, filing mandatory. By AOR, is AOR's presence necessary? Yes. So there are contempt notice that has been issued against AORs who did not appear, etc., etc. So they are officers of the court, and therefore it's their responsibility to instruct the arguing counsel. They have to be there, but sometimes they're not there. Yeah. Is somebody not on mute? How do I find out? Okay. Who is not on mute? Okay, thank you. Right. So so keep thinking if you can make it better. That's how you improve, right? That's it, guys. So anything else you would, oh, you have so many questions to ask. Why did I ask you this question? Yeah, so what you can do is, so I was telling you about the course. So let me first tell you about the course, and then we can proceed. Somebody is not on mute. Let me first. Mahavir, can you please put yourself on mute? I think I have, but I don't know how. Okay. Right. So let me first show you. I was telling you about the course, right? So this is a course I was talking about. This is a course developed by me. It's a certificate course in advanced Supreme Court practice, drafting, procedure, and strategy. I'll be conducting live classes, 2 live classes every week, right? So you can read this, and I'll just share the link with you so that you can read it whenever you want to, right? Okay, so, right. So you'll find things you get to learn in this, and all your questions, of course, were relating to, yeah. Yes, it is. So Manindra, we started this course right now so that it can help even the students who are appearing for this year. It will cover all the papers, and it's been prepared keeping that in mind. So yes, it will cover that. We're also doing a workshop on 4th. So we'll talk more about the AOR exam. The workshop for AOR exam is on 9th of February. On 9th of February, we are doing a workshop on how to crack AOR exam. So please do attend that if you're interested. So who should take this course? What career options will open for you? So it's not just that if you're planning to have a full-fledged practice in Supreme Court, even just like somebody was saying that they want to practice first in district court and then they want to move. They want to understand, right? So even for them, you will be in a better position to advise your client when they're going to the Supreme Court. It covers professional ethics too, yes. In Hindi, we are trying to get this in Hindi. So you just need to be a little patient with us. Right. So what we'll be doing in this course, so it will be experiential learning. So today this webinar was about, like I was telling you, I was giving you a lot of gyan, but what here we'll be doing in this course will be, I'll give you exercises. There will be weekly exercises. I'll ask you to do it. I'll give you feedback, just like I asked you to email me stuff. But before that, I'll also train you in, say we are looking at, I'll just show you. So these are the weekly exercises. So you'll get to draft all of these petitions. So even if you know how to draft, it will hone your skills. You will know exactly what is required, what can you do to improve, and all that with the help of exercises, right? All that with the help of feedback, and the exercises have been prepared, keeping that in mind. Yes, Shubham? You want to say something? Okay, right? So we'll be doing these exercises. And yes, Shubham? No? Okay. So we'll be doing jurisdictions, we'll be doing composition of benches. So these are more of theoretical aspects, but you still need to know if you have to practice the Supreme Court. These are important even for the AOR exam, but otherwise also if you do not know, then there's no question of practicing. What's the fee? Okay, so fee is 48,000. So what you can do is you can arrange, so you can write here in the chat box and somebody will get in touch with you. If you want to arrange a call with me, that can also be done. So they can answer all your questions, right? So you can just drop a message in the chat box. But otherwise it's 48,000, but there is some EMI schemes, etc. available. So they'll be able to explain that to you. Okay, so it's a 6-month course. Training methodology, I told you, there will be practical exercises, there will be live doubt clearing sessions. 2 online classes, I already told you, I'll be giving feedback during those classes. And also for drafting, I told you, we'll be giving weekly exercises and then I'll give you feedback on it. But along with that, when it comes to briefing and when it comes to arguing, as we were doing this session and I told you, we learn from mistakes, you need to practice and all that, we'll be doing role play simulations in the class. So that will give you a kind of practical exposure. We're trying to bridge the gap that exists between theory and practice, and therefore we have devised these kind of exercises that will give you a practical exposure to how it looks like, right? So even with drafting, that's the whole idea, so that when you know exactly how different it is, and you're so comfortable doing it. When you go to the Supreme Court, you already know it. If you're a student, you go for an internship, you leave a lasting impression on the senior, on the advocates, that, oh, you know how to do it. Even at this stage, just knowing how to do it should be like amazing, right? And if you're good at it, you may even start getting paid for it. So these are you can have a look at the syllabus. Somebody was asking about the AOR exam. So yes, so drafting, of course, the drafting paper gets completed. Practice and procedure, you saw we are completing that as well. Filing, etc. This is part of practice and procedure. We'll also be covering professional ethics, and this is just for AOR exam that we're covering. So we'll have all the material, the AOR exam, from the AOR exam paper, the important questions we'll ask you to solve. Even for leading cases, that's how we'll be working on it, right? Otherwise, when the classes are held by the Supreme Court, it's like towards the fag end, just before 1 month of the examination, you hardly get any time to prepare, and therefore the pass percentage can be very low, right? So therefore, and we'll be providing you with the templates as well. Yeah, so this is the course fee plan. It's 48,000, but just check, just drop a message and check about the EMI options, etc. Is it necessary to this course to practice in Apex Code? Shubham, so this is for to develop. So even if you're looking forward to developing a practice in future, even if you want to have a practice elsewhere, but you want to assist your clients, it's possible. So what you can always do, even if you're practicing like Jay, even if you're practicing in a district court, and when say there is an entry model, say order on charge, the client moves to the High Court, you handle High Court bid. Then the client comes to Supreme Court, or you don't handle even the High Court bid, forget it, you refer. Client comes to the Supreme Court, you tell him, oh, I know the matter inside out. The client will trust you more, right? Because you are going to handle the entire trial. So you have somebody in the Supreme Court who will file it. You have an AOR ready, you draft it. So when you do this course, you know how to draft, you draft it, you send it to the AOR, the AOR just files, takes that much filing fee. You come here, either if your client can pay, you brief a senior yourself, we're training you how to brief. Then you yourself argue, that's the option. You can build a practice. I told you there are lawyers who come and argue and go back. Does the course include High Court practicing procedure? No, High Court practicing procedure, the course does not include. It includes only Supreme Court practicing procedure. But to the extent you have drafting, etc., can help you even in the High Courts. But by and large, when I talk about practicing procedure, it will cover only Supreme Court. Right? Anything else you would want to ask about the so I will be doing webinars, lots of them for the next 14 days or so. So you can attend them. There's a workshop. I told you about the workshop. There's one happening on 4th, how newcomers can set up a successful Supreme Court practice. It's a 3-hour free workshop. You can register for it. There's the one coming up on 9th for your exam, right? And then you have, so you can attend these webinars as well. Are you ready to argue before the Supreme Court, or is it too early? So these webinars can answer many of your questions, actually. So these are designed in a way so that it covers whatever questions, concerns you may have. Can I develop a Supreme Court practice if I do not live in Delhi? Many of you can have that question, right? What common mistakes do lawyers make while arguing before the Supreme Court, right? Court craft at the Supreme Court, how to be effective before judges. For some of these sessions, there will be senior advocates, etc., coming in. Just like we had Justice 𝗵𝘃𝗺𝗧 the other day, we can have someone else as well. How any district court or high court lawyer can assist clients at the Supreme Court without losing them. This can be very important, right? Okay, so this is it, right? Anything else you would like to know? Anything else? No? Shall we close the session then? Did you like it? Didn't like it? I would want some feedback from you guys before we close it. Yeah? No? Ma'am, can we learn these techniques from you or other senior advocates? Shubham, I will be taking these classes, and I will also be bringing in others. Sorry, I'm saying other senior advocates. So I'll also be getting senior advocates to take these classes. So yeah, of course, you'll be learning from me. Thank you. Thank you so much for being so patient with me. I'm glad you liked the session. We'll again see you tomorrow. I really enjoy talking to you guys. Thank you. Thank you so much. See you. I'm expert. Yeah. Any concession, just speak to, I think you can just drop a message in the chat box. Somebody will get back to you. It's always good to just speak and find more about the course, find about the fee structure. Even if you are not sure, you can just have a conversation, right? Some enlightenment about the profession. Yeah, even I enjoy talking to you guys. Okay, then see you guys. Bye.